Todd,
Yes,
I
hi.
just made you the host, so you're good.
Oh, great, thank you.
All right, so I'm gonna duck off. Good luck.
Surprised to see you. Okay, great, thank you. Hello. Hi, Mark. Hello, Kate. Welcome, Kate.
How are you?
Great. Hello, Sarah.
Hello.
I
So
said,
good to see you.
you know,
My face today.
I called Ring Central today.
Oh, yeah.
There is a free version that you can use on an ongoing basis.
Oh, that's good to know.
That
Yeah.
is-
It's in a special place. So, I mean, I thought it was very interesting. Do you mind if we just talk about that thing yesterday, Todd, for a second?
Well, we need to start right on time, but yeah, we have some time right now.
Okay. I mean, I just thought it was interesting. The instructor, she was fantastic, and it was so great to have somebody who's not a family lawyer talk to us because you get a different perspective. But I thought it was interesting when she found out that we use Ring Central. It wasn't exactly a loud endorsement on her part, you know. So I thought that was kind of interesting.
Yeah. Mark,
But-
I like your hat.
Oh, thank you, thank you. You know, Todd, Sarah and I both went to Columbia. We both lived in the same dorm, but not at the same time. And I only was there for a summer in Carmen because my regular dorm was down the street. But, you know, I would just
You know what?
love-
I forgot to mention this, and I should, since we're chatting, that we are recording here. So,
Okay.
I don't think anybody said anything that they wouldn't want recorded, but be
No,
aware.
no. I'm on board. I'm on board. And
Mark
and
could be teaching this. I don't know why he's logging on to Custody 101, but
you know why I do it? Because I always learn something, and I do have a question today.
oh, well, fine.
Yeah.
That way.
And you know, you could never, like, for example, I studied German, and, you know, I was pretty good for a while. But when you go back to it, you're not too good if you don't keep up, you know?
Mm-hmm.
I was very interested in the comment yesterday about how to have an in-camera judge with child interview, because it was my understanding that in some instances the judge will postpone it until another time and then have the child in, but I guess they just don't do that anymore.
Yeah.
Hi, Miss Kate.
Hi, nice to meet everyone.
How are you?
I'm
Welcome,
doing
Kate.
well, thanks.
It's great to have you join us.
Great to
And
be
we
here.
have the clock. We have your clock in the background, so we keep track.
Oh yeah, I'm pretty sure that thing is on time.
We're expecting actually quite a few more people.
Okay.
So we're just chatting right now as we wait.
Great.
No, I thought it was a very helpful presentation, Mark, that we saw yesterday.
It was. Well, the reason I was so interested is I was telling Sarah after the meeting yesterday, I have a hearing on the 9 o'clock on Thursday.
Mhm.
So I said to my client, I said, I've never used this, and you haven't used it. Why don't we'll do a little practice with it tomorrow night? Because the instructor yesterday said, get some practice time. But I'm sure that the masters and the judges and realize that people are making their way with this,
Yeah, no, definitely. You know what? Each of the hearings I've done so far have been a learning experience. Like, I get it slightly better each time as I figure out how to do it. So.
Well, I sent all my evidence in this morning, all my, and I just wrote to them, please let me know if you get this okay, because it's my first time doing this. So I haven't got a response, so I guess it must be okay.
I never got any response when I emailed in the materials, but all of my hearings, they did get them with the exception of one. And then I had a huge back and forth with Master Godwin Pierce about that. So, but we figured it out, I think.
One of the big issues is that a lot of people, that this actually is something that has been challenging, and that is that some people on the other side, opposing parties who are pro se, do not always keep their addresses and their contact information up to date with the court. And although I'm very careful in how I deal with opposing party pro se litigants, I do tell them, you have to do that, because they, so.
I know, it creates some challenges.
Couple more minutes, yeah.
Sure.
Sorry, I just keep muting my audio because my neighbor has decided to re-roof his house today.
Of
So
course. That's
there's
good
a lot of
timing.
hammering noises.
On a rainy day.
Oh, I'm here in I'm in New Jersey temporarily, so it's nice here, but I think they're working to get done before weather comes.
Yeah.
Is that a coffee maker behind you?
No, it's one of those Margaritaville icy drink makers that
Even better.
yeah. It was I
Yeah.
think one of my family members got it as like a joke gift, and now it has a place of prominence in the kitchen.
I should hope so.
There's Dana joining us. Hi, Dana. Welcome.
Hi, Dana.
We're just chatting. We have a couple minutes before noon, so we're looking for, expecting some more people and just chatting as we wait. So,
Morning.
Dana, you didn't call me back the other day. Did you figure out what you needed?
I did actually. Thank
Good.
you. I appreciate you taking my call initially. Actually, the hearing was yesterday. It was
Good.
interesting.
Good.
It's not the smoothest situation down there. Let me just say that.
Nope.
I do Zoom for my other job quite a bit, and the invitation that the court had sent me for the custody hearing didn't work, and I had to go through several different ways to get on, but I was able to finally dial up. I mean, they're trying their best. I don't know if anyone else is dialed up into
The
it.
tech people are your friends. The tech people in the courtroom are actually quite helpful, and more so than most folks in the courthouse.
It was a good experience, but I just felt bad because it's tough, to handle the matters that way. So.
Well, I tell my client with this hearing coming up, I said, look, we're going to do our best. And it's new to everybody. And has anybody, Todd, Sarah, do you know this? Has anybody had a situation where they've actually said, we just can't do this. We want an in-person hearing? I understand it's an option.
I've talked with attorneys who are making those requests. I don't know what the results of those requests were. I also, I was ordered by one particular judge to appear in person for protracted. So I did a whole full day protracted trial in person recently, just a few weeks ago. And what he did was order counsel. There's counsel on the other side, and the judge ordered counsel and parties to attend in person, but all witnesses to be by phone, and then made a specific order that somebody else was to bring the child to the courthouse at a designated time in the afternoon. so that he interviewed the child in person. So it actually was, I was a little nervous about it, but it actually was okay because the courthouse is so empty. We were the only people on the floor, you know, so, and it was in a larger courtroom, so it felt like we had sufficient distance from each other during the hearing. But my only real complaint about the whole experience is actually wearing a mask all day with very little break is really eventually exhausting. So
They didn't require you to wear gloves. Larry Abel told me that he got something where he thought that we were requiring them to wear gloves to handle their exhibits in a protracted.
interesting. No, I did not. I actually had some in my bag, but I didn't use them. I just used sanitizer a lot throughout the day. So.
Well, actually, my opposing never showed up, and I was curious to see how that was going to be handled. The master had said, we called him, we spoke with him, we verified that he knew how to get onto the conference. He said he was going to do it, and then we all waited for about 15 minutes, and the master just said, okay, let it be on the record that he was able to and he didn't, and he's not showing up. And so that was interesting.
Yeah.
All right, I think we should probably get started because I don't want to, run overtime or anything like that. I want to make sure we can fit everything in. I'm not going to mute everyone. I thought about doing so, but I'm not going to because this is still a fairly small group. And feel free to ask questions, but just be mindful of the fact that we're going to, try to keep on a schedule and try to wrap up around, at 1:30. But having said that, I would like to introduce the two of us. You all sort of know us, but Sarah Katz is someone we're very lucky to have here today. She is a clinical professor at Temple University. She teaches the family law litigation clinic there and is somebody I could not live without because partly because
Feelings mutual, Todd.
her clinic takes many cases for VIP, primarily custody cases. Prior to her arrival at Temple, Sarah was supervising attorney in the family advocacy unit at Community Legal Services. She is a graduate of Penn Law School and Columbia University, as is Mark Allen Taylor as well. I just learned the Columbia part. And Sarah is also active in the Nicholas Cipriani family law in a court. So we're really lucky to have her here today. I am Todd Nothstein, you all know me. I have been a family law staff attorney at Philadelphia VIP since late 2017. My function is to recruit, train, and support volunteer attorneys who are taking pro bono cases in custody, support, adoption, divorce, and domestic abuse cases for us. I once had an academic career in American literature before I went to law school. Before coming to VIP, I spent most of my legal career clerking for Judge Messiah Jackson in the Civil Division, the major jury trial program. I still am active in the Cipriani Inner Court, and I'm a member of the executive committee of the Family Law Section of the Philadelphia Bar Association. And I went to Drexel, which I'm very proud of, actually. Drexel Law School.
I want to close the door, Stephen. Don't be a jerk. Oh, God. No, don't.
Hold on a second.
You might want to mute yourself if you're, there we go.
I'm sorry.
It's all right. It's all right. It happens. Anyway, so those are the introductions. Today is introduction to custody. Oh, I gotta let some people in from the waiting room. I got distracted. Good. I'm very glad to see we have more people showing up. So it's introduction to custody, which is just intended to give everyone a basic familiarity. We do anticipate having a lot of need coming up because many cases have been canceled and rescheduled. We have a lot of things on our list that just don't have, cases on our list that don't have dates, and we know that the dates are coming. So it's kind of like Game of Thrones here. Winter is coming. It's going to happen. We just don't know when. So I hope all of you will consider pitching in and doing your part and manning the wall, or staffing the wall, as it were, personing the wall. Having said that, I think I will just jump into screen share. Oh, and I should remind everybody, we are recording this so we can share it with folks at a later date. If you don't wish to be recorded, please, close your camera, turn off your camera or your mic. But we are recording this for use on our website. Okay, so I am screen sharing the PowerPoint. Does everybody see that? Very good, thank you. Okay, so I started to talk about how much need we have. This gives you some stats. We assisted in 70 cases, custody cases in 2019, but we received 119 requests. So I prefer to help in 119 cases when I get 119 requests, but that's not our realistic situation. And as I often like to remind people, litigants on their own face decisions about their most intimate relationships in a system they may not understand and that isn't designed for him. What I hear most often from clients I talk to at VIP about their experience going in pro se is, the judge didn't listen to me. I couldn't say anything. I didn't know how to make my point. And that's all about, being in a system that's not set up for somebody who's not an expert in, say, the rules of evidence, or familiar with the way things are done in court. And then we have some of the people we've been able to help on the side here. And in the top picture, you see Richard Coble, who is one of our great volunteers, who there with his client. I'm moving right along. I'm going to turn it over to Sarah now to talk about, basic custody principles.
Okay. All right. Thanks, everyone. And it's nice to see, I see some familiar faces and some new faces, but it's great to be here with all of you here. That slide is perfect.
All right.
And Todd, you may want to just double check that there's nobody else trying to join while you're
Oh, yeah. That's a good point. Thank you.
Except we lost our slide.
Oh.
Can we go one ahead? All right. Oh, right there. Perfect. Okay. So, so custody. So I think, maybe I'm telling you something that you already know, but the best interest of the child is really the guiding principle in making custody decisions. And that is the principle which guides every decision that the court must make. In Pennsylvania, what constitutes the best interest of the child is actually a statutory definition. It's defined in section 5328 of the custody statute with a set of 16 enumerated factors. And so the court is supposed to consider and weigh each of those factors as they relate to each party in whatever decision they're making with regard to the best interest of the child. Most states, like Pennsylvania, have an enumerated set of factors, a statutory set of factors that govern custody at this point, but this is ours, and the list of factors is in the manual that we provided in advance of this training. Next slide, please.
Oh.
The other really important thing that you need to consider and think about when you're thinking about assessing a custody case is the way that certain criminal convictions are given. So whereas section 5328 lays out the 16 custody factors, section 5329 creates a presumption of a threat of harm for people who have been charged with or have been convicted with, or really who have been convicted of a certain list of crimes that are enumerated in the statute. So what 5329 operates to do is to create a rebuttable presumption that attaches to certain convictions that are listed in the statute. If you take a look at section 5329, you will discover that the list of convictions to me feels a little random. There's some that you might expect to attach to a rebuttable presumption of threat of harm, like, you know, murdering the other parent, for example, is one. There's some pretty violent, horrible crimes that are on that list. There are also some nonviolent crimes. For example, crimes related to prostitution or any drug crime. So one of the sort of critiques of 5329 is it operates to sort of attach to this presumption somewhat equally, at least as a starting point, regardless of whether you know, were convicted of possessing a small amount of drugs, charges that aren't even necessarily pursued by our current DA's office, versus like if you were convicted of like running the drug ring, right? Those all get start with the starting point of
I'm sorry.
the presumption. Can we come back? Okay. The other thing that 5329 or 5329.1 also considers is any involvement with children and youth services. So the court is also supposed to consider whether or not any party has had a finding of child abuse or has had any kind of involvement, received any sort of services from children and youth. So that's a second part of the statute that becomes important. A really key practice tip is that, you know, anytime you're doing an interview with a client, you want to ask them about whether they have any criminal history, ask them whether or not they have any children and youth history. But you also want to verify that information to the extent possible. So at least in Pennsylvania, you can easily access criminal records. It's free to access the docket system. It's public record. So as a matter of practice, I always check the criminal history of my client, regardless of what they're telling me about whether they've been involved or not involved. And I also always check the criminal history of the opposing party. I also do that intermittently throughout the case. When you file a custody action, you are required, each party is required to fill out something called a criminal record and abuse history verification form. The parties are also asked to fill out that form at varying times throughout the life of the case if we're coming to court. Remains to be seen a little bit how that's handled, given we're not physically coming to court for the most part right now, with video hearings and phone hearings. But regardless, it's really good practice in your custody practice to just check from time to time, particularly in anticipation of a court date, because you certainly don't want to be surprised in the midst of a hearing to learn that your client has either a pending charge or a conviction that you didn't know about, because again, this presumption attaches. It is a rebuttable presumption, so the court can assess whether or not the person truly is a threat of harm. The court can also refer the person for an evaluation to make that assessment. The court can also require counseling to help address whatever threat might be posed as a result of the conviction based on the court's findings. So it doesn't serve as an absolute bar to getting custody, but it does create a speed bump in the process if a party has a conviction. And the statute also applies to household members. So, you know, if a party lives with somebody with one of these convictions, that can impact their ability to get custody. And I will say, just by way of sort of a broader picture about, you know, how custody practice works, that, you know, 5329 really has operated to the extent that anybody involved in the case does have one of these criminal convictions. It does help drive the direction of the case, for better or for worse. I mean, I don't necessarily agree with how the statute is written, but it is where our law stands right now. And as a result, I often can kind of predict where the case is going or not going based on what convictions might exist. So it does become fairly weighty determinative factor in terms of kind of assessing your case and likelihood of success on the merits. One other question that I get a lot is, what if somebody has a conviction that's not on the list enumerated in 5329? The court can consider those convictions because under 5328, which is all of the custody factors, the 16th factor is any other relevant consideration. So anything else that you think is relevant can be brought up. I mention that because, as I said, the list is a little bit random. For example, aggravated assault is on the list of 5329 offenses. Simple assault is not on the list. Terroristic threats is on the list. And so sometimes there are violent crimes, like for example, you want the court to consider a simple assault conviction by opposing party. You just need to bring it in a different way. You bring it in as a custody factor consideration. It does not have the same weight, that rebuttable presumption attached to it, but the court certainly can still consider it and weigh the relevance of that evidence. Let me just ask if there's any questions there before we move on to the next slide. Anyone? Okay.
Wait, did I do it again? I apologize for all of the clicking around. It seems like every time I touch my computer,
It's okay. It's a sensitive thing.
yeah.
Sarah, excuse me, I do have one question.
Sure.
During my custody hearing yesterday, the master had asked whether or not my client had been 320'd. Is that the right statute?
I think you mean 302.
I think you're thinking of
302. Yeah, 302'd. Is that right?
So 302 refers to our mental health code, which is an involuntary mental health hospitalization.
I found
The mental health of a party is definitely is one of the custody factors. So the court certainly has the ability to ask about any mental health diagnosis or history for each party or household member, and particularly if there has been something like an involuntary hospitalization, or any kind of diagnosis or treatment, that certainly gets weighed. It doesn't mean it's determinative, but it can be weighed.
I see.
Does that make sense?
Yes. Uh-huh.
Okay. Any other questions? All right. So when thinking about, a custody case, you really need to think there are two types of custody. There's physical custody and then there's legal custody. And as you'll see on this slide, there's different types of physical and different types of legal custody. So physical custody refers to who has physical possession of the child. Where is the child physically at this moment? Is the child in your home, in the other party's home, somebody else's home, and under what circumstances or conditions? Legal custody refers to the ability to make decisions about the child, particularly important decisions, for example, medical decisions, educational decisions, legal decisions of any kind. And so when you're talking with a custody client about what it is they're seeking, you want to be thinking about what sort of physical custody they're requesting and also what sort of legal custody they're requesting. There is no 50-50 presumption in Pennsylvania, at least not written into the statute. That said, I think in practice, you're going to find that most triers of fact, most masters and judges will be thinking in terms of, give me a good reason why I shouldn't do shared physical, meaning each party roughly shares the same amount of custody, and also shared legal. Each party roughly, each party has the same amount of legal decision-making power. The other options are, for example, primary physical. Maybe I, as the mother, have the child most of the time, and the child spends weekends with the other parent, and that other parent would have partial physical custody. So primary physical and partial physical. Sole physical refers to you are the only person who has a legal right to have the child. Now that is an important clarification there. So let's say, for example, sole physical is granted to one parent and but whatever has happened is that, that led up to that, that parent, the one with sole physical, decides they want the child to see the other parent. Sole physical doesn't prevent them from doing that. It just means they have the sole ability to possess the child and decide where the child is going to be. Similarly with shared legal means that you are making decisions together. So even though the parents are no longer together, they've separated, they are still expected to make major decisions together. And if they can't agree about those decisions, then they might have to go to court. For example, where the child might attend school, whether the child is going to get surgery or be put on a particular kind of medication. Those decisions have to be made jointly if you share legal custody with the other party. Whereas sole legal custody refers to having the sole ability to make those decisions. There's a fair amount of case law around the shared legal custody issues, and honestly, the kind of default, the expectation is that the parties will share legal custody unless there's some kind of evidence that a parent is unable to make those decisions or incapable of making good decisions or decisions that are in the child's best interest. The threshold is fairly, the court sets the bar pretty low in terms of the expectation that the parties be able to make decisions together. So the case law requires a minimum level of cooperation. So even though you may have a very high conflict custody situation, in most circumstances, the parties will end up sharing legal custody unless they truly can't. Sometimes the court will carve out sole legal decision making in a particular area. For example, I litigated a case last year through our clinic where the father was not willing to agree to certain terms that were in the child's individualized education plan. She received special education services. And so the court gave my client sole educational legal custody, but she still needs to make shared legal decisions around medical issues or other things that may come up for the child. So you can kind of carve out from that. I sort of skipped over mentioning supervised partial physical custody. So sometimes there may be safety issues involved in a case that result in a parent or party asking for the other party to be supervised while with the child. In non-COVID times, frequently that supervised partial physical custody in Philadelphia would take place in the court nursery, which is on the second floor of the family court building. That court nursery has been closed since March when the court shut down, and it's unclear exactly when, if at all, that will reopen in the near future. But supervised partial physical custody does not mean only supervised at the courthouse. It could be supervised by anybody. So if you can identify an appropriate adult to supervise the custody. For example, I have a client who's a parent who, although there are some substance abuse concerns about the other party, that party's sister is somebody who's trusted by my client. So the sister, the aunt of the children, is able to supervise the parent's partial physical custody so that party can still have time with the children. So you can be flexible in terms of who supervises. Again, I just want to stop and check if there's any questions. Okay. Todd, I think I'm turning it back to you, right?
Okay, so at this point, I am going to stop the screen share for a second. Well, perhaps more than a second, so that I can break it up just a little. And I thought it would be fun to ask everyone to get a sense of what everyone's ideas about custody are, and to ask a few questions to kind of get folks thinking about your ideas around custody. So I'm going to launch this poll and ask everybody to respond. Okay, so the first question here is, which of the following is not a factor courts will consider in awarding custody? And your choices are the child's preferences, the gender of the party, the physical condition of a party. So feel free to go ahead and answer that. Oh, by the way, this is anonymous. I don't know who's saying what. And then the next question is, what percentage of custody filings in Philadelphia Family Court are filed by self-represented litigants? And then finally, I have a little hypo. When Jim and Felipe broke up 3 years ago, they agreed Felipe would have primary custody of their daughter. Now Jim wants shared custody. What will the court do? So the options are deny Jim's request because he already agreed to the current arrangement and the daughter is used to it. Analyze the custody factors and determine whether shared legal custody is in the daughter's best, it's supposed to say interest. Somebody else entered this for me. So. Decide based on what the party's daughter wants. Okay, so it looks like almost everybody has answered in some way. Okay, so I'm going to end the poll. So everybody said the gender of the parties is not something that would be considered. That's correct. Our case law is pretty clear that the analysis should be gender neutral, and there is a statutory provision that provides that there's no presumption between parents. So as between parents, there's no presumption about who has custody, which would eliminate the possibility of a gender presumption between parents. So you all were on track with that. As for what percentage of custody filings in Philadelphia Family Court are filed by self-represented litigants, Judge Murphy, who is the administrative judge of Family Court, has consistently reported that that number is 85%. So only 6 of you guessed 85%. You were more hopeful, thinking maybe it was 62. But no, please know that about 85% of filings are consistently filed by self-represented litigants. So you are needed. And as for Jim and Felipe, there was no plurality of opinion among you. So you understand that it's analyzing the custody factors and determining whether shared legal custody is in the daughter's best interest. The daughter's preferences, the well-reasoned preferences of a child are just one factor that can be weighed. And the main point of this question was just to sort of bring up the fact that custody is pretty much modifiable, as pretty much always modifiable. That no custody order is necessarily forever. You can always seek modification. Jim would not be out of luck on that basis, but the factors will be analyzed anew. So I just thought that would be a fun way to ease into more details. So thank you for that. And I will now go back to screen sharing. Okay, so I am talking about, I'm just going to go through the basics of how you start a custody action. And before you start a custody action, you need to know if you're allowed to start a custody action. So who is allowed to start a custody action? Well, parents are always allowed to start a custody action. And people who are in loco parentis. And what that means, that has a two-part meaning. On the one hand, you have to assume parental duties, and on the other, you have to actually discharge parental duties to be considered in loco parentis. And if you haven't been doing that, you have that status, you can have standing to sue for custody. A grandparent may sue for any form of custody if they assume parental responsibility with the consent of the parent and one of the following is true. So it has to start out with parental consent. It can't be, the grandparent just took the child and the parent wasn't involved in that process at all. And then one of the 3 bullet points down at the bottom have to be true. The child has been adjudicated dependent. The child is substantially at risk from neglect, abuse, and the actual statute's a little longer than this, but substantially at risk. Or the child lived with the grandparent for 12 consecutive months and was removed from the grandparent, in which case, if that's your basis for standing, you have to file with it.
Training.
What's that?
Was there a question?
No, sorry, Tom.
No, that's fine. Thank you. Okay. So those are the basics of standing for any form of custody. Then, I'm sorry, I skipped a slide. Then there's this newer provision, which provides that any person who has a sustained, substantial, and sincere interest in the welfare of the child, if they are willing to assume parental duties and the parents have no form of care and control over the child. So this was introduced, the legislative history on this provision is that legislators were trying to respond to the opioid crisis, felt there were many people willing to take custody of children in communities, but didn't necessarily have those relationships already that were described on the previous slide. So you have to be willing to assume parental duties, and it has to be a situation where the parents just are not, there's no care, no form of care and control. They're not engaged at all. And they have to show, and I believe it's by clear and convincing. It's a clear and convincing standard, Sarah, for?
Well, I think it's just preponderance of the evidence.
Okay.
The rest of custody.
All right. So at any rate, that's an opportunity for somebody who's not directly related to the child or who hasn't been in loco parentis previously. Then there's another provision in which grandparents and great-grandparents can seek partial custody, as opposed to the other provision on the previous slide was all about any form of custody. This is just about partial. So you can seek partial custody under this provision where the relationship began with the parent's consent and a custody proceeding has been commenced and the parents disagree about whether the parties should have partial custody. So 2 parents are fighting over custody. They can agree about whether, the grandfather should be able to see the child and have partial custody time. That's when the grandfather gets to be heard and file. Essentially, he has to file a complaint, or can he be joined to the existing complaint, Sarah? Can a grandparent?
It gets heard kind of in conjunction with the existing complaint, but it's a separate hearing.
So the method to be heard is to file a complaint.
Mm-hmm.
Okay. And again, where the child lived with the grandparent or great-grandparent for 12 months and was subsequently removed. So if the grandparent only wants partial custody, they can seek that, but they do have to file within 6 months of that removal. And then the next slide I want to talk about, the next issue I want to talk about is simply preparing a complaint or petition to modify. So you start an action for custody by filing a complaint or by filing a petition to modify if there's an existing order. The complaint should include why custody is in the best interest of the child. So you need to make an argument based on factors that's best. I mean, it's not I don't want to create the perception that it's like, writing a legal brief. You're not.
There's no fact-specific pleading. So although you have to state your reason, that's all you really need to do is state a reason.
You just state your reason. But it's good to, I always in the help center, I always encourage clients to, cite a factor, right? Look at the factor, cite a factor, because that's stating a reason that it's in the best interest of the child. A petition to modify should explain why a change is in the best interest of the child. But I have been reading cases that say you don't have to have a change of circumstances. You just need to say that a change is in the best interest of the child. The types of custody are defined, and we already discussed them in the statute, but use those terms. I mean, specifically, the prayer for relief is very important. So say what you're asking for and use the appropriate statutory terms. People talk about visitation when what they really mean is partial custody. So, just be mindful that those terms are defined by statute. And the prayer for relief is vital because the parent has to be given notice of the consequences of the litigation. Anything to add to that, Sarah?
Just one other thing, which is that because of the standing slide, that if you have to assert in your complaint or petition to modify why you have standing. So particularly if your client is not a parent and is going to need to assert standing under some other grounds in the statute, it's incredibly important to include that. And that's part of the civil procedure rule. So it's necessary.
Great, thank you.
And I guess the one other thing just to add on the prayer for relief, you just made the point that it's really important to give the other party notice what the consequences of litigation are. Also, just as a practical matter, you can't ask for more than what you filed for. So if you filed for partial physical custody, you are then not able to go into court and say, actually, I want shared custody, or actually, I want primary physical custody. So the general rule of thumb, again, from a practice perspective, is always ask for more than you might actually want, right? At least ask for shared, even if you were really looking for something like partial, or ask for primary, even if you'd be okay with something less than that, because you can't go the other way. With that.
Fortunately, with VIP cases, you'll find most of our clients, if they have already filed, you don't tend to have to do filing, but they tend to just ask for sole physical and sole legal custody. They go in themselves, and because they don't necessarily know what they want, they've tended to do that. That is.
But you get a copy of their petition, because once in a while, a self-represented litigant makes a mistake, and really once you talk to the client, they want something different than what they filed for, and you may need to amend the petition if they really under-requested custody. So for example, if they really wanted shared and they only filed for partial, and you really want to go for shared, you need to amend that petition and ask for shared.
Good advice, thanks. Okay, and then how to file. So I wanted this training to be, just a foundation for what is normally the case, but nothing that is normal is happening right now. So in pre-COVID circumstances, you filed in person at 1501 Arch Street on the 11th floor. There is no e-filing in family court. You had to take an original and 3 copies, one of which is redacted. And by redacted, I mean you remove a child's name and address. And you can file with a confidential address if a party is fearful about domestic violence, along with the domestic relations information sheet and a criminal record verification, which has that whole list from 5329 and asks a person to sign a verification stating that they are or are not convicted of any of those things, as well as anyone in their household. So you take those in, you get time-stamped copies, then the time-stamped copies are what you serve on the other party, and you keep a copy for your records. Currently, however, you can't go into family court, into the clerk's office. So the procedure is that you either mail or email all non-emergency filings. And the email is drclerkroutine@courts.phila.gov. Or it can be mailed to the clerk's office, and the address is there. So you mail it. You do need to also send a criminal record verification and the domestic relations information sheet. And if there are minors' names in the pleading, which there will be in a custody complaint, you should send a redacted copy as well. There is a note in the early part of the manual that I sent to everyone about what the procedures are right now. Be aware there's a different set of procedures for emergencies, but we'll talk about them later. But they're set forth in your manual too. And also for VIP cases, always make sure to file IFP paperwork along with the complaint. If the client is already filed, the chances are very high that they've already filed an IFP, which is informa pauperis. There's a sample recipe to proceed IFP in your manual, and it's available on the VIP website, and you can always contact me for just a form recipe. But send that along via email, or there will be a delay in the filing because they'll be waiting for a filing fee.
Yeah, and right, for those of you who are tuning in to be able to do this within your own private practice, if you have paying clients, you do need to then mail in the check or money order after the filing by email.
Right. And it's supposed to come 3 days within 3 days of the filing. Any questions about that?
This is where they're impoverished basically, and they don't pay the filing fee.
Correct.
Yeah, exactly. It stands for,
which is true for all VIP clients.
IFP stands for informa pauperis, and all our clients have to be out of below 200% of the federal poverty level. And so we're able simply to file for them by recipe. It's good to know though that if a pro se litigant goes in on their own and needs to file informa pauperis, they're going to be given a long form which asks them to divulge their income and state if they have any benefits or not, because people on benefits are generally automatically approved. But it's a little bit more complicated of a thing to fill out. It's a few pages, and it's about their income. Whereas for a VIP client, you can just submit this recipe and you're good. So
is there any general time frame on how long it takes the DR clerk routine to add a document that's been filed? I filed entry of appearance last week. It's still not there, and I've reached out to the court but haven't heard back.
So usually it's fairly quick, but specifically for entries of appearance, you can just, if you're an attorney, email them to customer service. So if you want to follow up with me afterwards, I can give you the attorney liaison email, or actually maybe I can just post it in the chat. I'll pull it and post it in the chat.
Great.
But you can do those without filing them through DR Clerk, but I've been finding they show up fairly quickly.
Okay.
Yeah. You might want to reach out to find out if there's a reason.
I did. I called the attorney line at the court and left a voicemail, but they haven't gotten back to me. I talked to the court administration office, and they said I have to go through the attorney line. So
I recommend using the email.
Okay.
Which is the attorney liaison. So the attorney liaison at customer service.
Okay.
I'm putting it in the chat right now.
Great, thank you.
So.
Okay.
Thanks, Kate. Any other questions?
Kathy Berry?
Sorry, it's just how it pasted. Kathleen Berry at Paces.com. But my experience has been it's been fairly quick to get it. All right, is this me, Todd?
This is you.
Okay. So now that this petition, either a complaint for custody or a petition to modify custody has been filed, the first stop in almost every custody case is going to be before a custody master. And custody masters are attorneys who have been designated by the administrative judge to hear custody cases. And they have sort of limited powers. They can only hear certain types of matters. So they can hold a full record hearing if the request is for partial physical custody or supervised physical custody. So to the extent that a party, that's what they're asking for, the master's conference is going to be your trial. You put on testimony, you put on evidence. And what will happen is the custody master will then enter what is called, or issue what is called a proposed order. So you don't find out the result then and there. You hold the hearing, they close the record, and they say you'll receive my proposed order in the mail. Sometimes they tell you what it might look like. Sometimes you're left guessing. But once you receive that proposed order, each party has 20 days to file exceptions if they don't agree with that order. An exception means that you are asserting that the trier of fact, the custody master, made either a legal error or a factual error. So it's like an appellate standard. So it's not just, I disagree with this result, but you really have to assess whether or not you feel that an error occurred. If no exceptions are filed, the proposed order becomes a final order. If exceptions are filed, the case gets scheduled before a judge for a hearing on the exceptions. And the one little interesting twist about that, I don't know if I'm jumping ahead, is that when you file exceptions on a custody order, it does vacate the order, which means things can be left in a bit of chaos because now there's no order. If there was no previous order, there's now no order. It's up to the parties whether they follow that order in the meantime or follow some other arrangement, but it can create circumstances where it's really unclear what, if anything, should happen if there's not agreement between the parties about what custody is there. I think we'll talk about exceptions hearings a little later on, right? As a judge hearing.
Yeah.
Okay. Can we go to the next slide? Okay. If it's not a request for partial custody, then a master is going to hold what's called a conference. And these are non-record proceedings really with the goal of trying to settle the case. The master will, seek to identify the issues, party A, what are you asking for? Party B, what are you asking for? Is there any possibility of an agreement? Sometimes even a conference can turn into a little bit of a mini hearing. So this is, again, a strategic thing. If you feel like there are what are called compelling circumstances in your case, you can ask that a master hold, in essence, a mini hearing on those compelling circumstances and issue what's called an interim order. So for example, if there really are safety issues, if there's a substance abuse issue, a mental health issue, criminal convictions, you might be arguing that there are compelling circumstances that warrant an interim order, in part so that you don't end up in that sort of gray zone, like I mentioned, of doing a proposed order and then having the order be vacated and then not knowing what's going to happen or how to ascertain the safety of the children. So when an interim order is issued, the case is getting a date before a judge, but there's also an interim order that is enforceable in the meantime. A master can also sort of set the case up to make sure some things will happen. For example, asking a judge to sign off on an order for drug and alcohol testing or for counseling or for a mental health evaluation. The master may explicitly hear about, things that are going on in the case. For example, there was prior children and youth involvement, the Department of Human Services, or DHS in Philadelphia, may order the DHS file to be provided to the court or order other documents to be produced. So in essence, the conference sort of sets the case up for trial before a judge, or it settles the case, right? One or the other. A master's absolutely empowered to enter an agreement. So to the extent that the parties agree, the master can enter that order right then and there, and then it's not necessary to go before a judge. Any questions on what I've said so far? I think, Dana, you might be muted and talking. I don't know. Oh, no. Okay.
Okay.
Keep going. Okay. So, as I mentioned, not every case can be resolved before a master, but that is usually your first step. if your case is listed for trial before a judge, you're usually going on a hearing list. And so you're getting a 30-minute slot. Not very long, but that's how the court is designating it. If you're on what's called a trial list, that's about 1.5 hours. If you think, as the attorney of record, that you will need more time than either a 30-minute or hour-and-a-half slot, you need to file a motion for either a semi-protracted or protracted hearing, semi being a half-day hearing and protracted being a whole-day hearing. The masters are not empowered to list the case for semi or protracted. You do have to file a motion to do that. They are empowered, however, to designate it for a hearing list or a trial list. So that is something you can request at the masters conference level. But either way, even the longest hearing, a protracted hearing, is still not a tremendous amount of time given the significance of what we're addressing in custody cases. And so it's really important to really narrow the issues and try to focus the time you have with the court on the things that are going to be the most significant for your client. So in custody, as with most areas of family law, there's simply just a lot of client counseling that has to happen, where you really kind of work with your client to determine what are our biggest priorities. What are the top 2 or 3 things that we want to make sure the judge hears and does, and try to sort of focus the testimony and evidence on those most important things, because much more than that, you probably won't get to it, and also may end up with a very frustrated judge. Any questions on that? Okay, next slide. As I mentioned, I think we already talked about this. So protracted and semi-protracted matters are longer. So some things that will that would be a basis to be requesting semi-protracted or protracted hearings. You really need to have more witnesses than just the parties and the child or children. So usually, because you're going to need to file a motion that says, here's why we need more time. And usually the kinds of things that I'm putting in that motion are going to be, here's the witnesses that we need to hear from. Maybe there's extensive documentary evidence that needs to be produced and reviewed by the court. Maybe there's just a lot of children, right? Which might be a reason, because it takes a long time to interview each child separately. But in short, you're sort of making a case for why this case is a little more complex than your average custody matter, and then you will get that half-day or full-day hearing. Next slide. Okay. So back when we were just talking a minute ago about master's hearings, we talked about how generally the master will issue a proposed order, and then each party has the ability to file exceptions. It's really important to know that your exceptions hearing is not a new trial. It will feel, for those of you who have appellate experience, a lot more like an appellate argument in a way, because again, the judge is really looking for you to make an argument about why there was legal error or factual error, just getting a fact wrong. The judge may take very limited testimony, for example, asking clarifying questions of the parties, but they are not going to interview the child again or hear a whole new direct testimony from your client. You actually have to order the transcript. You should be making arguments about the transcript before the master. And then after that exceptions hearing, the judge can grant the exceptions, deny in all or in part the exceptions, enter a new custody order, or they could remand it back to the custody master, although I've seen that less frequently. Usually the judge figures it out right then and there, unless they really feel like the master made the kind of error like refusing to hear from a witness who's not been produced that day or something like that, and then they might remand it back. The judge also could relist it before themselves or before another judge. So I'm not sure the rule quite anticipates that, but that is that is certainly something that I've seen happen. When you're filing exceptions, so just to go back to that, you really need to be super clear about what were the errors that the master made. And one thing to really consider and to think about is, you know, you may not agree with the result, but you as the attorney need to do a little bit of an objective analysis to kind of figure out, is this really an error, or are we just unhappy with how the master weighed the factors? And, you know, make a decision between, do we file exceptions, or do we sort of see how this goes and then potentially file to modify if it's not going well, for example, if circumstances change. So that's a determination you might need to help counsel your client on.
Sarah,
Oh, sorry, go ahead, Joel, please.
how much time has to pass before you seek an exception? I mean, I assume not an exception, a modification. I mean, I assume that you kind of have this choice where some time period passes and you can seek a modification from the master, or you can choose to say, no, he was in error, and seek a different result that way.
Yeah. The order has to, there is no bar on filing to modify a final order. So the order has to be final. So if, you know, you get a proposed order, you have 20 days to file exceptions, and then if nobody files anything, then the order becomes final. But once that order is final, theoretically, you could file to modify it. You know, so I mean, some of it depends on what's happened in the meantime. And I guess another sort of practice tip to parse out is it that we're disagreeing with what the master did, or is it that the master did the best, you know, made the best decision they could with the record they had in front of us, but other stuff has happened in the meantime, right? Which sort of changes the calculus. And for me, that would then weigh in favor of let this order become final and then file to modify it, right? Because if you have new evidence you want to present that wasn't made available to the master, maybe you sort of alluded to the possibility that some of these bad things might happen, but you didn't have a crystal ball and you didn't know, and now bad things are happening, you might want to wait to file to modify that order as opposed to filing exceptions.
What if you look at your record and you kind of say, oh, wow, I kind of missed this or something like that, and it's not actually all that new, but you're seeing where you may have not done as well and you're modifying based on trying to do better?
Well, I think again, it needs to be new evidence. So it needs to be that, you know, evidence that the master didn't hear. So I think the calculus is really, is there truly error by the master, or is it simply that you don't agree with the result and you want the court to consider other evidence that maybe they didn't consider, or maybe you didn't produce, but I mean, for whatever reason, if it wasn't before the court, it's not going to, in front of the master, it's not going to be considered by the judge either. Again, because the exceptions hearing is not a new
Thank you.
trial. Yeah. Any other questions?
So because the transcript is so important at this stage, I want to sort of ask you to spend a little bit of time on getting transcripts. And specifically, so if a VIP volunteer went to the master's hearing with a client and that client wants to file exceptions, the volunteer is a really good volunteer and wants to stick with the case and help them file exceptions and believes there are grounds, can that transcript be obtained with the IFP petition?
It can. So this is a little bit of a funky process, so I'll try to just walk you through it. So if the client filed on their own using an IFP petition on their own, and then you entered, you know, so IFP was granted affirmatively because they filed an IFP petition and they were allowed to file without paying the fee. There, then you can just submit a request. There's a form to submit the request for the transcript, and you just put that it's IFP, and that goes to the master's hearing. If the matter was filed by either paying a fee, so for example, the person scrabbled together the money to pay the fee for the complaint or petition, or maybe even you filed it using that precipice to proceed, which is really a certification of no fee. It's not quite the same thing as an IFP petition. The court is going to want you to file a new petition for IFP for the purposes of obtaining the transcript, which you can do. And I can give you an example of how to do. But basically, you just get an IFP order. So this is one of the few times where that certification of no fee or precipice of no fee doesn't help you. You actually need to get an IFP order specific to the transcript, and then you can attach that to the request for the transcript and get it for free.
And do
So
requests go to the master's unit or?
good question. Yes. So for master's transcripts, they go to the master's unit. There's different forms and a different process for kind of each place in the court you're trying to get a transcript from. But if you're trying to get a custody master's transcript, it goes to the custody master's unit. If it's a judge's hearing transcript, then that goes to the central like digital transcript records at the court interpreters and court reporters office for the first judicial district. So it's a little bit of a different process.
Thank you. I sort of knew those answers, but I was more comfortable hearing it again from you. So
That's
thank
fine.
you.
But also if you get stuck, just call or email me and I'll walk you through it or give you my form. So
Thank
okay.
you.
Any other questions? Is this you or is this me, Todd? I can't remember.
I think I can take it.
Okay.
That's fine. So there is something called consolidated case management, which means that, you know, more complicated cases that are going to involve a lot of motions. So it's not complicated in the sense that a protracted hearing has it's not about having witnesses, it's about multiple motions being necessary. And it would also have to be protracted. So you can make a motion for consolidated case management, and that means one judge will hear all those pending motions. And it alleviates the problem of getting different rulings from different judges throughout the life of a case. And you know, it can be done in custody, divorce, and support. And I think that's actually, unless Sarah wants to add something, I think that's really all we need to say about it, because I haven't seen it happening in very many cases, or
doesn't.
cases.
It comes up more when you're handling divorces that encompass the custody and support claims as well.
Okay, but it's just good to know about if somebody's talking to you about it. That's what it is. You make a motion for consolidated case management because there are going to be a lot of motions in the case. And then the next step is expedited custody relief. So while you're waiting, I called it, because you go to the master and it needs to be listed before a judge. It gets listed before a judge. And last year, we were seeing judges' dates about 9 months out from when they were being set at one point. Then it got much better in January when 3 new judges joined family court, but then COVID happened, and so I don't know what the dates are going to be like. But sometimes there are issues that come up that are just, you know, your clients feel that every issue is really urgent. But there are things that are time sensitive that require judicial intervention in between the time that you've gone to a master and the case is going to be heard before a judge. And one example of those cases are no access cases, right? So maybe there's not an order in place, or in any case that, you know, the party just isn't getting access to the child. You can file for contempt, but that's only going to make that's not going to cause a modification, for one thing, and that's also going to be listed before a judge further down. So you need to file for expedited relief. Also, some educational issues, but specifically not school choice, may be appropriate. So I think that's the case where the child maybe isn't going to school when he's with dad, or he just is suddenly not doing well in school, where now that he's spending more time at mom's, right? Those kinds of issues might be appropriate for expedited relief because they're time sensitive. The longer that goes on, the more of a problem the child's going to have. Sarah, do you have any other examples of good cases for expedited relief?
I mean, the no access one is sort of the best one. Sometimes just a really, yeah, I mean, sometimes a really discrete issue, like, I don't know, silly education is another issue where it comes up. But yeah, I really would reserve it for the no access or very limited access cases.
Okay.
Or if there's some actually, here's a really good example. There is a custody order in place, but there's a new safety concern that needs to be addressed quickly. For example, a new criminal charge by the other side, and you want to limit or cut off custody because of it, or a new, something else kind of drastic, like a mental health hospitalization or something like that, like something that creates a safety issue for the child that may not, we'll talk about emergencies, it may not rise to the level of imminent threat that an emergency would require, but it still needs to be addressed in a relatively urgent manner. That would be appropriate for expedited relief as well.
Could I ask a quick question?
Mm-hmm.
If you have parties that have never had any order in place, and they've done pretty well, and then all of a sudden, one of the person that has the child decides that the other person can't see them, then in this case, you'd file a complaint for custody and simultaneously a petition for expedited relief. Is that correct?
That, at least historically, particularly if there's a no access or very limited access kind of situation, that would be how we handled it. In part, we handled it that way because getting that initial master's date took a while. Pre-COVID, the court kind of caught up with adding masters so that the master's dates and the expedited dates were almost kind of around the same time. So if you use that procedure that you just mentioned, Mark, you might end up with the expedited hearing and the master's hearing like the same week or within a week of each other. So it becomes more of a strategic decision, which is this something a master could even address? Because if it's a new complaint, but there's a safety issue, it may or may not fall under, what a master can do. So that's kind of a calculus that you have to make. And I mean, I guess at least in practice, I haven't been seeing the court listing expedited yet. I'm aware of at least a couple in cases that I am familiar with, and they haven't assigned dates. So I'm not quite clear what the process is going to be right now in the sort of pandemic age that we are experiencing.
So, and that sort of ties to the next bullet point, which is that there has to be an underlying custody action, or one must be filed simultaneously with a motion for expedited relief. So the point is, you have something going on, you've got a complaint filed, or you've got a petition to modify, and you're asking that be expedited to get a discrete issue before a judge. So you're saying, so you can do that simultaneously, or it has to already have been done.
Yep.
Now, normally, which is a word I'm using a lot lately, motions for expedited relief are only accepted on Mondays by the Clerk of Family Court. That doesn't make sense right now because we're doing everything by email and mail, and Judge Murphy has informed the family law section, that you can mail them or email them any time, Monday through Friday. And the idea was that a hearing would be scheduled before a judge. It was typically around 4 to 6 weeks out. When I went in to file an expedited, the clerk would tell me, when the dates were that day. Like they can usually give you a good idea. Oh, well, expediteds are, this far away, which also gives it can be strategic, right? Because you may decide, well, I don't need to do this, right? They're 6 weeks out and a master's hearing is going to come up. But that was generally the time frame, around 4 to 6 weeks. They used to always be scheduled on Friday. And the clerk gives you a rule to show cause, which I assume now this will come back via email to you.
We'll see.
I mean, right?
Yeah.
That's what they're sort of saying. It should come back. You get this rule to show cause with the next available date, and that's what you need to serve that on the party. So this is the other piece about expedited. Personal service on the opposing party or counsel must be made forthwith. They don't really tell you what forthwith means. I found no definition in law or in practice, except it's just don't wait, just do it. It's, you know, a party can sort of show up and argue that they didn't have enough information, and that'll be up to the judge to determine, or enough notice, and that'll be up to the judge to determine. An affidavit of service must be brought to the hearing. Mark, did you have a point? I thought you raised your hand.
Yeah, when it says personal service, can you just mail it to them? And I mean,
No.
No, it has to be actual personal service for an expedited motion.
by a
So
third party?
I usually use a process server for this. If there is an appropriate third party, you know, maybe there's somebody more neutral that could safely serve the other party.
So if you're looking for a third party to do it, it needs to be an adult who is neither a party to the action or a relative of the party to the action, or an employee. So you as the attorney in that same case can't serve it, and it can't be a relative of a party, or an employee. So that's something to be aware of.
So question, I mean, we've been
Not-
talking about,
Not a,
You cut out, Joel.
I'm sorry. We were talking about improper petitions, about filing fees. I mean, I would assume that a process server is even more expensive. So what are we doing there?
So my first advice would be to try to find a third party who's not a relative or a party. If that's just, you know, if the client doesn't have anybody in their life who could do that, then I'd say talk to us at VIP. You know, if it's a VIP case, we do have some process servers who do discounted rates if it's service in the city. That'll cost a client about $40 or $45, and there are occasions where we can find funds for that, but it has to be pre-approved by our management. Did you have another idea, Sarah?
Yeah, I mean, we have a account with Heaven Sent, which is one. I mean, not to make an endorsement, but they're just one of the legal process servers in Philadelphia, and they give us a reduced rate because all of our clients are low income, and we just pay the money if we can't come up with another way to safely do it. Sometimes it's easy to figure out, right? Like sometimes there's just someone we can identify, or even if it's safe for the parties, you know, like we can sometimes, you know, sort it out. So you just have to kind of figure it out on a case-by-case basis.
what I've done with VIP clients when I needed a process server is, we did once have somebody who did it at a discount, but what I did with Heaven Sent, for example, is I made arrangements for the VIP client to pay for the service. I can't remember if they got a discount, but to pay with a credit card, and they wanted that to get that up front, and then they executed the service, and it worked out very well.
Mm-hmm.
Okay. Yeah, it is, you know, there are hurdles, and, you know, at least the clients are not having to pay for the legal services through us, but, you know, we aren't able to eliminate every layer of barrier, unfortunately, but that it is a consideration. Oh, wait, I don't think I was done. Why does it keep doing that? Sorry.
Todd, we should just keep an eye on the time because it's
Okay.
almost.
All right. So, no, I guess I was done.
Yeah.
The court date that you have down the road will usually remain in place unless the judge has for some reason, like, dealt with all the issues in the case. And then there are emergency petitions. So if there's no outstanding custody action, you, just like with expedited petitions, you have to have an underlying petition or file one. it has to be filed with a proposed order and a rule to show cause. And if you do that, a custody master will hear the petition ex parte the same day that it's filed. Relief will only be granted if the petitioner can show that a child is in imminent danger. So that means imminent. It's pretty narrowly construed. The procedure for filing is laid out in your manual. Since we're becoming time conscious, I don't want to linger on that procedure. It's laid out pretty clearly, I think. But I think you should understand that this is not just, I haven't seen my child in a while. This is, I have reason to believe harm is going to happen to my child or is happening to my child. Does that sound right to you, Sarah?
Yeah, now the tip that I would give you with regard to emergency filings is that usually I am only successful in filing them is if I have a witness or witnesses that can corroborate the danger that I'm alleging is happening, right? So usually that means, maybe you have a child who has been mental health hospitalized and is saying, if you send me back to parent A's house, I will harm myself again, right? And you have the doctor available to testify and say, I find this credible. I think this child will experience physical harm, like actual self-harm, if they go back in the care of this parent. Or you have DHS involved and you have an investigation pending of a child abuse allegation, and DHS is making a recommendation that this child should not go back, or maybe the child is old enough to testify and say, I'm scared, I believe I will be physically abused. Another tip is, I've had this argument a lot when I've done these hearings. I have not had a lot of success arguing imminent emotional danger as opposed to imminent physical danger. So I'm not saying don't file them if you think there's some emotional danger, but know that you're less likely to be successful, at least in my practice experience. What the court is really looking for is a physical safety threat to the child.
Sarah, is it a witness or an affidavit?
A witness. You need to have a witness available. You might want to allege that, sometimes I'll get a letter or an affidavit from somebody to attach to the filing if I can. But otherwise, you might make representations in your pleading saying, if called to testify, Dr. So-and-so would say, or, that sort of thing. You might have a treating, psychologist or therapist that could be used in that capacity as well. But yeah, you really are looking for some sort of imminent. And I guess the last, I know we're like belaboring the emergency custody proceedings, is just simply like, what makes this an emergency today versus yesterday or, 2 weeks from now, right? So the imminence piece of it is also very, very important. Something like, this child's supposed to be discharged from the hospital this week, so we think something would happen, will happen. Not that they've already been discharged. They did go to dad's. They weren't that happy about it, but they came home fine, right? Like, now you've kind of lost the imminence aspect of it.
Thank you.
Sure.
So these are just some procedural points. You should try to notify the other side if it's possible that you're going into doing this. At the conclusion of the hearing, the emergency master submits recommendations that are reviewed by the designated liaison judge. And if the petition is granted, a hearing will be scheduled in approximately 10 days so the opposing party can be heard. And that's just the basics. It's very simple. Directions for filing are in your manual. I am trying to speed along a little bit, so I'll give this, Sarah, can you talk about contempt?
Sure. So in cases where there already is a custody order in place, sometimes there are circumstances where a party is not following the custody petition. And your client may have already filed a petition for contempt, or you may decide to file a petition for contempt. A petition for contempt has to allege an actual willful failure to follow the existing order. So it's not just I disagree with what's happening or I want to change in the order. It's really, really important to keep in mind that the goal of a contempt petition is to either enforce the order as it is currently written and or to seek sanctions against a party. And the sanctions in the contempt statute include incarceration, include probation, include monetary fines, things that for the most part almost never happen in custody cases. The really important thing is that a judge hearing a contempt petition does not have the authority to modify the order on the contempt petition. So if what you really want is, the other side's not following this order, so I want the order changed, you actually want a petition to modify, and you may or may not find contempt. And so the calculus, and this is one of those things that self-represented litigants mess up every single time, because they think, well, the other parent is not taking advantage of their custody time, so therefore I want to file for contempt. But you need to have a conversation with your client. Is what you want for the other parent to actually come every weekend? Or is what you want to stop those weekends from being in order? Because every 7th weekend they decide to actually exercise their custody, right? So sometimes you don't want contempt at all because you don't want the order enforced. You want it modified. And sometimes you want contempt because they're really not, the order says the other parent gets the child from Friday to Saturday, and routinely they're keeping the child till Sunday, and there's a whole back and forth and calling the police every time to get the child back, or maybe the order has something very specific, like the parties alternate weeks, but each parent is responsible for doing the child's homework during the week they have the child, or doing, making sure they get their schoolwork done, and they're not doing the schoolwork, right? And it's in the order, so it's a willful failure to follow what's in the order. So contempt, is a tool. It's sort of a limited tool, and so you have to really think about what is my goal in filing something. And I can't tell you how many times I've had self-represented parties come to us for representation, and we end up withdrawing their contempt petition and filing to modify instead, because they never really understood what they were filing, and contempt wasn't the right action. Questions on that? Okay.
Okay, and this is still you, Sarah.
Okay. So just so generally, with regard to the question of children coming to court, so generally at the master's level, right, the starting point for the vast majority of custody cases, children are not required to appear, and you actually need to make a written request in order to have a child appear. I will tell you that in my experience, these requests are usually denied. Usually the master will say, you know what, have the parties come, and we'll see if we need the child. And then when that happens, they hear testimony, and they might say, you know what, I did need to hear from the child, come back tomorrow or next week, or that kind of thing. It's been rare that I've had a written request to have the child be present at the initial listing before the master be granted in advance of hearing any testimony or evidence about what's going on. So generally, children do not participate in master's hearings. Whereas the notice you receive for every judge's hearing says that children are to attend those hearings. So the expectation is when you're going before a judge that you are bringing the children, unless you write and specifically ask that the children be excused, or the child be excused. Sometimes the judges will, if there's a good reason to excuse the child, maybe the child's very young, maybe there's, some other good reason that you don't want the child to attend, the judge may grant that request. But if the judge orders they attend anyway, you need to bring the child. The procedure when you bring a child, at least in normal times, to the courthouse is you bring them with you to the courtroom to check in. And then you either need to bring someone with you to sit with the child when the parties go in if they're younger and can't sit by themselves, or they need to go to the court nursery, which is on the 2nd floor of the courthouse. Obviously, things are a little bit different now, with most hearings being via video. So, you know, you may, if you expect or want a child to testify in your video hearing, you may want to make a specific ask of the judge hearing the case about how they want to handle that. Next slide.
Okay, I think that wraps it up, right?
Yeah, go ahead.
Okay. So the next question, of course, is whether or not you are ready to say yes. And I have a final poll for you on that point. Now the answers here are not anonymous. I'm going to be able to find out who you are because I do want to know when you might be interested in taking a custody case. So the choices are September, October, and before the end of the year. Bearing in mind that we are starting to get some dates in, so we want to know when you might be able to help us out there. I'll give you plenty of time to do that, and while you're doing that, I will.
Could I ask a quick question?
Mm-hmm.
Are people, I'm not seeing any clients in person, but are some of you Zooming with potential clients in order to get to know them? I'm thinking that I'm going to move in that direction, but I haven't done that yet. Todd, are we doing it at VIP?
I'm sorry, can you run the question by me again?
Yeah, in your initial consultation with a prospective client, are you using Zoom videoing so you can chat back and forth? I haven't done that yet because I don't want to meet people in person right now, even though our setup at the office is fantastic, you know?
Well, I mean, I think
I do.
When the clients will work out together, you know, like, do you want to do it by phone? Do you want to do it by Zoom? I don't know. Did I talk over someone? I'm sorry.
No, I talked over you. I'm sorry. I do. I'd rather not meet with people in person as well. That's my ordinary course of business now.
Yeah, I've been offering to clients if they want to meet by Zoom that I'm happy to do that. But so far, most of them do not take me up on it. And I don't know totally why that is, but that's fine. We've been doing most of our work by phone. That may change, you know, as things start to pick up, but.
Okay, I have 8 of 11 folks responding to the poll, so I'm going to keep leaving that up there for a bit. And then last, did anyone have another question?
Yeah, I have one. So I really don't have to do anything in person, and while I'm tempted not to fill this out right now just because during the pandemic, I know that I don't want to do anything in person. So.
Well, but we should clarify that the court is almost exclusively holding hearings via video and phone right now. The court does have the discretion to order parties and counsel to appear in person, but it's rare. And you would know that likely if and when a court date is assigned. So if that makes it any more inviting to do right now, what the court is doing is hearings via something called Ring Central, which is very, very similar to Zoom.
Yeah, I guess my concern is, and maybe this is not reasonable, is the minute you step over the threshold, if the court says for any reason, we want you to appear in person, you'd have no ability to say no.
I mean, Todd needs to answer that in terms of what VIP would do in that circumstance. But
yeah, I think if it came to that and you absolutely couldn't go, we would probably try to find a different volunteer for that case. So, you know, we wouldn't want you taking a risk that you can't take. I mean, I don't think, you know, it's sort of fine. If you're more comfortable waiting a little while and just contacting us then that's fine. You know, like I said, we would try to replace you on the case if it came to that. So you just kind of have to weigh it and make your own judgment, I guess.
Thank you.
Yeah. Any other questions?
Yes, Todd, while we're here, that half-hour thing that you wanted people to sign up for with the court, does this training
The attorney consultation program?
Yes. Does this qualify, this course Would you say that qualifies us to do that?
I feel like that should be more experienced practitioners than just having sat through this course, just because it's easier for people who've been practicing a long time to give, useful advice in a short time frame. So I guess my short answer to that is, although I'd love to have people's help, I do prefer that those consultations be with more experienced family law folks.
Todd, if I could contact you after the meeting to tell you what my experience was, and you let me know whether you think that you would give a green light, because I'm a hybrid or tweener, I guess.
Sure. Okay.
We can talk afterwards if that's okay.
Okay. Sure.
I don't think I even know what this is. Sorry.
Oh, Larry was asking about a program that we have at VIP, which is our attorney consultation program that we launched to try and help folks get basic information about getting started, and we ask practitioners to give them a 30-minute consultation, but it also includes giving those clients kind of options counseling about what they should file and what they might want to do in their particular situation, and then advising them about how to file and get started at Philadelphia Family Court. And so, his question was, after taking our training today, would it make you somebody who should be helping us with those consultations? And I just said that, I'd rather that be sort of more experienced folks, but if you've been practicing family law for a while, we'd love to have your help with that. Does that answer everybody? Okay, any other questions? All right, so as you see,
I'll just put out there one last little plug, okay. Todd, that if you do take these cases, I routinely, Todd is a support for you if you take the case, but also I routinely mentor folks, anyone who does agree to take a case and feels like, gosh, I don't know what to do, or I'd like some perspective on how to do this. There's a sort of open offer to give me a call or an email, and we'll talk about it and figure out what you need to do next. Okay.
We have many mentors, and Sarah's one of the very best. We have, if I am a little confused, I'm often turning to Sarah or other mentors. And so we try to collaborate to make sure that you have the support that you need. You have the manual now, and I hope you'll consider helping us out.
I'll say one thing if I can. I'm still very much a newbie, and I also do not want to go to court in person. I'm fearful of that situation. But I think that if you can select a case that's coming up quickly, the chances are of you having to go in are very slim. And also, I haven't had that many, but the clients are very well versed in in their own case, so it's a good situation. You're not going in there totally blind, but good mentorship, absolutely, and I've been thankful for that. So it's easy to do.
Yeah, I think a good rule of thumb in terms of whether there's a possibility of being ordered to go in person is if the case seems like it might go to a protracted or semi-protracted. It seems like some of the judges are ordering in person for those longer hearings, not all of them. But if it's a master's hearing or a shorter judge's hearing, it's pretty unlikely that you'd be ordered to be in person.
I can just chime in. I'm not excited about going anywhere in person either, but should somebody else take a case that they've worked up and it turns into an in-person at the last minute, I would be willing to go and cover that hearing. So I understand the concern, the hesitation, but I think that there are a lot of people out there that would pitch in too.
Yeah, that's a very kind offer. It's good.
Yeah, I will say, I think we were chatting about this as people were coming on, that, thus far this summer, I've done one in-person hearing, and as much as I did personally have some anxiety about it, in the end, the experience was not a bad one, because the courthouse is close to the public right now, and there's very few people in the building. We were it was 2 attorneys and 2 parties, and we had lots of distance between us in a fairly large courtroom, with the judge up on the bench. And there really, other than a couple of court staff and a sheriff on the floor, was really nobody else that we saw that day. And so as much as it felt weird to be in an almost empty building, it didn't end up feeling that uncomfortable in the end. But obviously everyone has to make their own choices.
You know, I'm willing,
right now.
I'm willing to help too, because I live very near the courthouse. And if there was an emergency and somebody needed backup to go into the courtroom, I would help out. I mean, I might not be available if you call me at 9 in the morning, but I'm willing to be a backup if necessary. I call it being a standby.
That's really kind, Mark and Melissa. Thank you for that. That's good to know. I do want to know you'll get an evaluation in the mail, and you can only help me by filling that out and letting me know what you thought. And our case list is there. I want to say about our current custody case list, which is on our website at phillyvip.org. Most of the cases don't have dates attached to them right now. There's one coming up in September that does. It's been a real struggle that it's hard to pitch cases to people when we can't tell them that the court date is a certain day. If you have the kind of flexibility in your work schedule where you can take that case, start working with the client, and plan enter an appearance so that you're advised of the court date, we would greatly appreciate that. It's a little bit of a gamble. If you end up being unavailable on the day, I think you should immediately request a continuance once you get that court date. Or if it becomes a date you absolutely cannot do, we try to work with you to get that case covered as well. But I do hope you'll consider taking a look at that case list, because there are compelling stories, but a lot of them don't have dates attached to them. And that's just the struggle we're having, waiting for the court to tell us when these cases are going to be. All right. Anything else anyone wants to say or ask? Or?
Just really quickly, just for clarification about service, do I get that even if someone has a lawyer, you have to personally serve that lawyer an expedited motion?
Yeah, let me clarify that one. So no, not necessarily. If the other side has, yes, the rule says personal service is required, and it's actually personal service on the party, not the lawyer. But this was the question that came up in the chat. You can use an affidavit of acceptance of service. So particularly if there is a lawyer on the other side, usually I just reach out to that person and say, look, I just filed this. Will you accept service on behalf of your client? I'll send you a form to sign. And mostly people will, unless there's some issue about whether this person is still their client or that kind of thing, like if they can't find the person. But so certainly if there's counsel on the other side, the challenge becomes a lot of times there's not counsel on the other side, right? Okay. And then
so there is professional courtesy. There is professional courtesy extended amongst our bar.
Absolutely. So what my experience has been is people are usually willing to accept service as long as they truly have been retained and are, counsel of record. I sometimes run into issues with people saying, well, I used to represent that person, but this would be a new matter and I need to talk to that, and then who knows what happens. But I would, if there's counsel on the other side, I absolutely would start with contacting them and just seeing if they would accept it.
Thank you for clarifying.
Yeah, no, that's a good question.
Okay.
All right.
I see what's going on. I wasn't able to keep up with the chat very well when I was screen sharing, so thank you for covering those. Okay, anything else? All done?
No, but if questions come up, feel free to reach out. I'm happy to help if I can.
Yeah.
I am so sorry to ask one more question. Do you guys know from your inside sources, is there any likelihood of this thing's going to stay this way? Meaning even after COVID is gone, we may be having video hearings for these little short hour hearings?
It's a great question. I don't think anyone truly knows the answer to it yet. It's certainly our reality for at least for now. The court already has canceled all hearings through the end of the year and is rescheduling them via video. So that we know. Anything that was scheduled from March 17th, which was the day the court closed down, through December 31st of this year was canceled and is in the court. That's what's taking so long. The court is rescheduling all of these matters via video. But obviously I think this will likely still be with us by the end of the year. And so I think there's a good chance that will be extended into 2021. I don't know what the future looks like beyond that.
So we're like on call at home, basically. You have a time and you're sitting by your computer doing your work until you get buzzed or beeped, however.
Yeah.
Great. Good.
We'll see.
Okay. Thank you, guys.
Yeah. All right. Thanks, everyone.
Thank you.
Thanks.
All right.
Bye.
Thanks, guys.
Bye-bye.